Hello and welcome to another episode of the Opus Well Style Podcast. My name is Iván Watanabe, and I am really excited to have on today Angela and Michael Shofner from Shofner Consulting LLC. Thank you both for coming on today. Honestly, I'm really excited to have you come on. We've had conversations. I think you're going to bring a ton of value to our physician clients that are out there. So thank you both for coming on today.
Thank you.
Yeah, we're excited to be here.
Awesome. So we were just figuring out sort of titles and roles, behind the scenes here. And so we have Angela, the CEO and owner, and we've got Michael, the new COO of the organization and making the operations run. So, as we kind of get into it, why don't you just tell the audience a little bit more about yourselves and sort of your roles and the organization itself?
All right.
Yeah.
Go ahead, hon.
Okay. So, the operation, primarily what we do is physician contract review. So from start to finish, we're kind of, reviewing the contracts for both legal pitfalls as well as compensation information, and overall just trying to make sure that those contracts look safe for our clients, and that, they're aware of any kind of problem areas, and hopefully, that employer will be willing to address and make some changes if there are pitfalls. But if not, either backing out or at least being fully aware of those issues as that physician enters the contract. And so that's primarily what I do. I'm reading those contracts, I'm meeting with clients, sending notes, sometimes doing negotiations depending on the client's needs. And that's my role.
Great. And as COO, I'm in the background helping to make sure that things run efficiently, that clients are, in the calendar, that meetings are arranged, doing some intake. And then I also have a role as a physician recruiter, where I, if a client is talking to Angela and maybe the contract's not a good, agreement, then I will be happy to help them, get in touch with another recruiter. So just another thing that I offer.
Love that. No, I appreciate it. And, it's funny, we sort of bonded over this LinkedIn post recently that I had, and my thesis around physicians in general sort of being trained over time through their training, through their education system, through their careers, and ultimately leading to a loss of agency and a loss of control over their careers. And that's sort of what I'm seeing as people come to me, whether it's they're finishing up fellowship, they're new attendings, or they're 75 years old about to retire physicians. There is this sort of general theme I see around loss of agency and career, as my wife is an anesthesiologist, I feel a sense of responsibility to sort of, help this community of physicians. And I know there might be some listening folks out there that say, well, they're highly compensated individuals. How bad can you feel for them? But it's less about the compensation and more about sort of this construct of potentially feeling stuck and regardless of income, kind of, being in a situation that may not be favorable for them. And so, I think that was a bonding point for us. And I know your background in education really lends yourself to sort of, again, being an advocate for the physician family. So we really appreciate you. And I'm excited to have you on.
Yeah, absolutely.
As you're going through contracts, and I know for the folks that are finishing up their training and are starting to review contracts and interviewing, what are some of the most common things that you're seeing in contracts today that are easy red flags, easy things to notice that you're saying, hey, you should absolutely not sign this because of X?
Yeah. So I think, of course, this varies for each physician because everyone is going to have different priorities. So, but one big thing that is a big red flag for me is if a contract doesn't have an ability for the physician to terminate without cause, right? So sometimes I see this and it might be, 1 year or 2 years or 3 years that this physician is really locked in. And if they're reading it on their own, they might not either realize that that's not an option and they get down a year and they're miserable and they try to put in their notice and their employer then says, you don't have the ability to terminate without cause for the first 3 years of this contract. So you're just kind of stuck here unless you're going to breach the contract, right? And then you're going to have to pay us damages. And damages could be like that employer's lost revenue for the rest of that term that they weren't allowed to terminate without cause, right? So that's a huge, and to be clear, I don't see that a lot, but maybe in 10 to 20% of contracts, there's this inability to terminate without cause. So, if a physician is just happy, right, and the employer is good, maybe that's not going to be an issue for them. But until you kind of get in there, you don't know exactly what you're in for. So that inability to leave the contract is a huge issue that I see. That and, non-compete clauses that are overly restrictive. Some non-competes, what I'm looking for in a non-compete, if it's legal in the state where the physician is practicing, because sometimes employers are still trying to put non-competes in a contract in a state where they're not allowed to have one, right? So making sure that it complies with the law. But, the more metropolitan, the more densely populated area that you're working in, the smaller that restricted area should be, right? So if you're way out in Montana, maybe a 30-mile non-compete is, I hesitate to say reasonable, but certainly more reasonable than if you're in New York City or even in New Jersey or Chicago, right?
Yeah. So I think there's sort of one quick point I wanted to make in general is, and you're probably seeing this as well, physicians finishing up training and then signing contracts without actually reviewing them. For all the physicians out there, review your contracts, review the agreement before you sign it. Like, have it discussed, have a good understanding of what you are actually signing, because imagine a situation where, as Angela just mentioned, you're locked into an organization for 3 years and you're miserable, right? And you want to leave, and then you have to pay damages to get out of that contract. Like, it's not like a car lease where I, pay a couple $1,000s. I mean, this could be significant financial damage to you to pay back to get out of a contract that you could have had reviewed in advance. So we'll start with that part of it. And then, the non-compete clause is super interesting because, as you said, in Montana, that mileage could make a lot of sense. In New York City, that puts you out, all that could potentially limit out, a ton of Westchester, all of Manhattan, some of New Jersey, some of Connecticut, like, Long Island's out, like that could be punitive, right? You'd have to move to a different part of the country in order for you to get out of that particular contract, if that's what the non-compete clause look like. And, the other thing that I don't necessarily think people are factoring in is acquisition. Right. So, if the non-compete is a potential area, but, you're at X, Y, and Z hospital system and there's nobody in your potential area, so you're not really threatened. But then Northwell goes and buys a hospital near you, and then you're now running into a situation where that mileage has now extended based on an acquisition. Like, that is not considered at all when folks are reviewing their non-competes. I don't know if you're running into that or sort of what your thoughts are on that.
Yeah. So if at all possible, I always want that non-compete to be restricted from just the physician's primary practice location. So anytime that employer is saying it's going to be from any of our locations, like, that's potentially problematic, right? And if at all possible, we want to get it restricted to just the location that they're working in the majority of their clinical time.
Yeah. And how receptive do you find the employers to be as you're having this dialogue and sort of advocating in on behalf of the physicians? Is it 50% of the time that there's some movement in here? It's becoming increasingly lower and lower and lower. Like, what are your thoughts right now?
So it just varies wildly. Some employers who I don't expect will be willing to make any changes surprise me and are willing to make, significant changes. Some absolutely will not, right? So at that point, I'm going to be talking with my client and saying, here are the pitfalls that we see. You know, are these deal breakers for you? I want you to consider the next, 3 years of your life. Is this your long-term geographic goal,
Mm.
right? Is this where you want to live long term? If not, sometimes I have a client who's like, if this doesn't work out, I'm probably going to be moving across the country to be closer to family, right? So maybe that non-compete is not a deal breaker for that client. And that's, again, why I like to have that, why every contract and every situation is unique, right? Um, but it certainly can be a deal breaker um, if it's going to mean that you would have to move uproot your family, right?
Hmm.
To be able to continue doing your job. So some employers, when I come back asking for, a reduction in that mileage in that restricted area, they'll just say no. Some will be willing to limit it to just that primary location. Some will be willing to restrict the mileage a little bit smaller. Once in a blue moon, they'll take out the non-compete completely. That's pretty rare.
Mm.
I would say probably 50% is probably a little high, maybe more like 30 to 40% of employers are willing to negotiate at all on the non-compete.
Hmm.
And usually we're just talking about, for instance, the idea of acquisition, right? Sometimes we can limit it to the locations that exist at the time that the contract is created, right?
Hmm.
So that can be, if they're not willing to move on the other things and it's restricting from multiple locations, can we get it restricted from just the locations that exist right now, instead of, if they continue to acquire, it being enforceable from all of those new locations as
Yeah.
well.
It's funny because I oftentimes, I don't know what the makeup is of your practice, but oftentimes I think that initial contract is kind of what gets reviewed. But if you're employed with a group and that group gets bought out by another organization, you're signing a new contract. Oftentimes, that new contract needs to be reviewed again, right? My wife's practice was acquired by private equity, and there was another review of the contract that needed to be done because obviously there's some changes that kind of go in there. And as private equity continues to gobble up different organizations, different practices, you should treat that like a brand new employer, right? Because it truly, really is a brand new employer. And so don't think that just because you're still at the same job that contract will remain the same. I mean, I don't know how often you're running into it, but I'm assuming more often nowadays than prior.
Yeah, absolutely. I would say, and not just with private equity, but for instance, I had a physician who signed on with HCA and they were working at this particular facility, and HCA decided that facility was probably not profitable enough for them. So they were really trying to spin it off, not to private equity, but to another employer, right? And that employer came in and said, they were calling it an assignment of the contract. So this is really important. When you assign a contract, the terms, the material terms, the terms of the contract that go to the heart of the deal should remain the same, right? If they don't, I don't think it's a valid assignment. It's really more of a termination without cause, and then a new employer offering you a new contract. And that's really what we ended up saying, because the terms of the contract that, they were saying were an assignment were not materially the same as the original contract. And so importantly for that doctor, because he had only been with them for a few months at that time, he had received a pretty significant sign-on bonus from HCA. And we were able to argue with HCA, this is not an assignment of the contract. Really, this is a termination without cause. And that means that sign-on bonus was forgiven for
Gotcha.
him instead of him having to repay it.
What a valuable way to advocate for them, right? I mean,
Yeah.
that physician likely wouldn't have been able to do that on their own.
Yeah.
So
And I'll say, for me, I care about my clients and I don't want them to be in a bad situation. And I think, that he had come to me on the original review of that contract. And then we worked together to get that sign-on bonus forgiven, and he got out of that situation. And we've worked together a couple more times as he's moved around. And he's settled now. He's been in his new position for a year or two, right? And so I haven't heard from him for a little while. But, every time that he kind of is considering something new, he does come back to me. And I think, because he trusts me that I'm going to take care of him.
That's wonderful. And in terms of some of the other ancillary, reviews that you all see in the marketplace, are you able to help folks with reviewing, compensation, how it compares to the market? If so, like, how are you doing that? I know that's one of the things that's offered on the website, right? So I'm just curious kind of how you're going about doing it. And obviously that's incredibly valuable to be able to compare what you're getting paid against the market, right? So tell us a little bit more about that.
Michael, do you want to take that one?
Sure. Yeah. So we have an agreement with MGMA where we are able to share compensation with clients, and we have it for every specialty, for academic, non-academic, for geographic locations. So using that data, when our clients come to us with their contracts, we're able to say this is a reasonable offer based on the compensation in that region. It's a good deal, and based on that, we encourage you to move forward if you're comfortable with all the other pieces, of course. There are times when we've been able to advocate for higher compensation just using that MGMA data as a background. Also, with my background in physician recruiting, I'm able to get a sense of the marketplace from other recruiters that I've talked to on various websites. So,
yeah, and sometimes it's also looking through past contracts for that specialty. If it's pulm crit, going and kind of diving into all the pulm crit contracts I've done in the last year to, especially those smaller specialties. Sometimes the MGMA data is, sometimes the data set is not really large, right? So kind of diving into our own records to see what other physicians in that specialty have been receiving.
Yeah, I mean, that's incredibly valuable. I'm thinking about my wife and recently sort of going through a contract negotiation. She had to take like 7 or 8 interviews to try to gather her own data. We put together a spreadsheet, put together some comps, put together sort of a presentation. Then she had to go back to the PE organization and say, hey, listen, this is what market rate is compared to what you all are compensating per this hourly rate and this amount of patients. And, it took a ton of effort on her and a little bit on my part to be able to sort of put this thing together. So to be able to have access to the comp data, understanding whether or not, you're being compensated fairly, because again, there's nothing against, I understand the track, but seeing the light at the end of the tunnel can sometimes blind physicians to sign these things and not advocate and not understand and not negotiate and feel like you don't have the agency to ask for more compensation. So I'm grateful for an organization like you both to be able to do that for folks and to say, hey, listen, like, that might be a great offer. $450,000 sounds like a really healthy salary, but your peers are getting paid $550, right?
Mm-hmm.
That's real money left on the table, and so you should be trying to advocate for yourself to get every piece of it. So, again, I think that's an incredibly valuable benefit that you all offer. In terms of some of the other ancillary benefits that you're either advocating for or seeing in contracts, or ways that maybe you're going to sacrifice a little bit on the non-compete, but the other ways where you find where you find that your clients are able to juice up the contract a little bit for their benefit, are there any sort of, low hanging fruit or things that you typically ask for that might be a benefit?
Yeah, so there are quite a few kind of small things that you can try to, get added. And these are all kind of probably more, compensation wise, but, asking for, particularly if you're a physician just coming out of residency or fellowship, asking for that employer to reimburse the costs of your medical license, your DEA license, those types of costs that you're having. Now, you're not going to get them right when you're paying for them. It's going to be at your start date, right? So, but still, if you just spent a couple thousand and you've been in residency or fellowship, a couple thousand is meaningful, right? So asking for that. Sometimes we can get that higher sign-on bonus. Sometimes, and this is more likely to come with a more experienced physician, if it's particularly if you're someone that this institution really needs and values, right? So I had a client recently who was taking an academic position. It was a really high need that this institution was looking to fill. And, this doctor wanted more time off, essentially. And, the institution had and this is pretty typical for academic institutions, they have a set amount of PTO for every physician. But what we were able to do is go back in and ask for more CME days, right? So he was able to get some extra time, right? And maybe he's able to take his family on those CME trips, right? So he's still getting that family time, and maybe it's not exactly how we want, but it is a little more time off.
Yeah.
Now,
It's a
I
really
would say,
creative. That's a really creative way to go about doing that, because you're right. Then other people get a wind of how much PTO somebody has, and really sort of they start comparing. Well, why does that person have more PTO than I have? And I know that can create some friction within a practice. So the CME one is a really interesting creative way to go about doing that.
yeah, and again, that's probably something that's more for someone a little bit later in their career most of the time. So, but it's something to try, right? If that's your high priority, right? Is having more flexibility in your schedule, more time off, more time with your family. It might be something that's available to you. I had a pathologist recently who she really wanted a standing desk, right? So, getting those kinds of things. Now, that is actually not something that we put into the contract, but it was part of our negotiations, right? So there are a lot of little ways, but again, that's why I like to meet with my clients, so that I know what those priorities are.
Yeah. Are there, one typical one that I think at least folks should be aware of is their tail coverage, right? Significant risk on the back end of your employment. So can you just share a little bit more about what tail coverage is and kind of how it works, and either, what the opportunity might look like to protect yourself a little bit better?
Yeah. So tail coverage is essentially your malpractice insurance that's going to cover a claim that, the original incident that led to that claim occurred while you were employed, but they don't bring that lawsuit until you are no longer working there, right? So every malpractice claim is going to have some kind of statute of limitations, and that's, how long after that event occurred that individual can bring the claim before it's kind of barred by state law or federal law that, like maybe it's 3 years, right? You have to bring that claim within 3 years of when the event occurred. And so the tail coverage is going to protect you for that time after you're no longer employed, but while that patient or family member could still bring that claim, right? Was that
Yeah, perfect.
clear as mud? Okay. So it is really important. And what a lot of doctors might not know is that probably every future employer is going to require that you have tail coverage for all the work you did in the past, right? And it can be quite expensive. We're talking tens of thousands of dollars to buy it, you know. So some employers will provide your tail coverage. There are basically two kinds of insurance policies. The first is an occurrence-based policy. An occurrence-based policy does not require a separate tail coverage policy. It's all wrapped in. So it's going to cover a claim whenever that claim is brought, right? And then there's a claims-made policy, and a claims-made policy will require a separate tail coverage policy. Some employers will have that occurrence-based policy. I see this most often with like hospitals, academic institutions. If it's a large employer, they're more likely to have an occurrence-based policy or to provide a separate tail coverage policy when you leave. More often, I would say probably 80% of private practice is not going to pay for your tail coverage, and you're going to have to pay for it on your own. So again, physicians have different priorities, and some physicians like being employed by a hospital or a physician employment group and just kind of receiving that steady paycheck. They're not interested in a more entrepreneurial role, right? And so more likely it's kind of a lower risk, right? And probably a lower reward also, right? And that's okay, right? And some physicians are looking more for, having their own practice or that ability to have that really high growth. But just kind of be aware that with that private practice, you're much less likely to have your employer covering your tail. So, I see all of these as valid options, and I don't see, that there's any bad way to do this. It just depends on your priorities, and where you want to end up in your career. But definitely a much higher likelihood of having to pay for your own tail coverage if you're in private practice.
Yeah, and again, I think the bottom line for me is to be aware of what you're signing, be aware of what is available, be aware of what the risks look like upon separation, in general, across the board, right? And they obviously need you all as experts to review the contract and know what they're signing, know what the benefits look like, and know if there is a separation, kind of what that risk could look like. Because without that coverage in place, and if you did get sued, significant amounts of money, and to pay for a policy, the premiums on a tail coverage that you're individually paying for is significant as well. So you have to build that into the economics of the decision upon your exit. If you really are going to sort of pursue your own path and there wasn't any coverage in place, you have to kind of understand what that looks like when you're evaluating the entire picture, not just incomes, not just, private versus public, trying to really understand the full picture. And I think that's one of the other reasons why I think you all are so valuable to advocate for them. So, I appreciate you guys. As we kind of wrap up, are there any one or two things that you want to make sure that the listening audience kind of takes away from our conversation, or anything in particular that you want them to know?
Michael, do you have anything?
Maybe in a second.
Okay. I'll just say, I think, I know that there's a cost involved in having an attorney review your contract. We do offer a payment plan, and particularly that can be helpful for residents and fellows, right? I think my goal, I have two goals with every client and every contract. And the first one is just to make sure that my client understands the contract, right? So that they're walking into it eyes wide open. So, if it's a pretty good contract, they understand any pitfalls that there might be. And two is to protect them, right? So if we can make changes to make the contract better, let's try, right? So not all employers will be willing to make those changes. And at that point, we have to evaluate, were these deal breaker issues or not. But just kind of be aware. I think that there's value, even if we can't get the contract changed, in having a really full understanding of your contract.
I'll go ahead and add, we have some clients that will come to us with the intent of moving forward with a certain organization. This is somebody they know, a place they want to live, whatever the case may be. And they're very, focused on that, which is, it can be good, but we have seen many times where things don't work out quite the way that they wanted to. The leadership changed, the financials changed, something like that. And also, we've had people that the CEO promised something, the CEO left, and the new CEO came in and was like, I don't see anything in writing. Mm-hmm. They're not going to follow that. So when a physician is exploring options, I encourage in the initial interviewing stage to get a couple of offers to make sure you have a backup plan. And you can also use that as leverage in your negotiating. This is your first choice, and you tell your first choice, this is what I'd like to do, but I have another offer that's slightly higher. Could you, get a little closer on that base compensation?
Yeah.
But also, if things do go wrong in an organization, then maybe you have something as a backup.
Yeah, and get it in writing.
Yeah, that's good legal advice. That's great. That's great legal advice, I should say. Well, listen, I really appreciate you both and what you are doing. Again, we are all in alignment here. We're trying to advocate for the physician community. Make sure that you are reviewing your contracts, advocating for yourselves. You're in the power position. There are many options available out in the marketplace for you. So, understand that you've got physician, recruiting background, you've got the legal background, you've got a team here available to help you when you are reviewing these options. So please, I implore you to just understand what you are getting involved in at the very least, right? So you going in, as you said, Angela, with eyes wide open. So thank you both for coming on today. If the listening audience wants to contact you just to find out more about your services, where can they go? How can they find you?
Yeah, my email address is angela@shofnerconsultingllc.com.
And the website is shofnerconsultingllc.com. You can find her phone number and email address there as well.
Perfect. We'll be sure to tag you on all the social media, all the platforms where this podcast was released. So to the listening audience, if you want to find them, you can find them through us. And if you have any questions or need anything from us, please feel free to reach out. But I really appreciate you both for coming on. Thank you so much for what you're doing. And thank you to the listening audience for tuning in. Please click subscribe below to be notified when we release our next episode. Thank you all.